for it. Thank you, Mr. Speaker.
Mr. Chair,
Dr. Kem Calder.
Mr. Speaker, it's a huge pleasure to rise and take a very brief call on the Habeas Corpus Amendment Bill, and I appreciate the contributions from all sides of the House, and I notice it's with great delight and pleasure that the whole House is supporting this bill, and I commend my colleague Chris Okenvold for his eminently pragmatic bill, and I must say I do appreciate the contributions of Mr. Charles Seville, both in Select Committee and in the House on matters legal, but I did find his comments today a trifle judgmental and churlish, and especially in regard to the filibustering on the Royal Society Bill that the other side was party to only a few short months ago in this very chamber. Now, I wasn't a great Latin scholar. Mr. Speaker, but the words habeas corpus, as far as I can tell, and I only did it to fifth form, to year 11. I did manage to get through School C, and I can still remember the first line in the Latin primer: supra est via Romana, via et lata et recta est. Above is a Roman road, the road is broad and straight, and I can still remember that. Habeas corpus, I think, means you have the body, and I was wondering what Sir William Seo and the Honourable David Cunliffe were speaking about in the House during this debate, and I wondered if the new cleanly shaven, trim and tanned Olympic hopeful haircut on David Cunliffe and my colleague from Southall, Winfield, was saying, habeas corpus, you have the body. You have the body to be a leader of our party. You have the body to be a leader of our party. Now, that was just a thought. I can't confirm that. I can't confirm that. Of course, another David could say, Ecce, Davidus, habeas corpus. Alas, David, you have the body. But then again, it has to be a living body, as we heard from a previous speaker talking about a cow in Mumbai. It has to be a living body, so that may be a lying call with some members of the Labour caucus. Colleagues, it is an ancient writ. It has been called a great writ, and not being of the legal fraternity. I did look up Blackstone's commentaries, which of course is the repository of all legal wisdom, and I learnt that habeas corpus ad subjudiendum was actually a writ issued first in the reign of King Edward I in 1305. There had been other writs, as we've heard, preceding that with a similar target, but the basis of the writ is that the king is at all times entitled to have an account. Why the liberty of any of his subjects is restrained wherever that restraint may be inflicted upon him. So basically asking the question, is that detention lawful? And the writ exists basically to ask that question and to protect thereby personal liberty of a subject and citizen. Then, as now, the writ of habeas corpus issued by a sovereign, a superior court, is in the name of the sovereign and commands an addressee, perhaps a sheriff, a lower court or a private subject, to produce the prisoner before a royal court of law. We have heard an excellent summary from my colleague to McIndoe, the chairman of the Justice and Elections Committee, and also Mr. Okenville, outlining the history of how it came to pass that in 1997 the Law Commission decided that we needed to simplify procedures for dealing with habeas corpus in New Zealand jurisdiction. This led to the Habeas Corpus Act of 2001, which implemented changes of that report and formalised habeas corpus in legislation. There were, however, some anomalies which have been pointed out by previous speakers, and this 2007 the Law Commission, in consultation with judiciary and government agencies, came up with the report that we are considering now, and as Charles Seville so well pointed out, forms the basis of this legislation. I do commend this bill to the House.
Chris Farfoy.
Mr. Speaker, thank you very much for the opportunity.